In other news now, the Supreme Court took on Texas's controversial abortion law today. National political correspondent Alex Miller has more on the 3 hours of lively arguments made in front of the High Court and what we can expect next.
Supreme Court justices heard not one but 2 cases Monday relating to the controversial Texas abortion law enacted 2 months ago.
United States versus Texas, General Prelogger.
But the hours worth of arguments didn't focus on a woman's right to abortion or even on overturning Roe versus Wade as much as whether or not the case should have been brought before the justices and what siding with the state would mean for other laws.
If Texas can nullify Roe and Casey in this manner, then other states could do the same with other constitutional rights or other decisions of this court that they disfavor.
Lawyers for the Department of Justice and for the abortion providers at Whole Woman's Health argue that should the court agree with Texas, it would mean states would be free to ignore Supreme Court precedent and enact their own workaround laws on any issue.
It's the rules that have been created by the Texas legislature that turn courts into a weapon that can be used to nullify constitutional rights.
Texas's Solicitor General faced pointed questions from both liberal and conservative justices, including Justice Brett Kavanaugh.
This will be across the board equally applicable as the Firearms Policy Coalition says to all constitutional rights.
Yes, but I'd add one more point, Your Honor.
And you've also said the amount of the penalty doesn't matter. $1 million per sale. You know, anyone, a state passes a law, anyone who declines to provide a good or service for use in a same-sex marriage, $1 million is sued by anyone in the state. That's exempt from pre-enforcement review.
Again, Your Honor, what we'd have to have, for example, in
specifically...
Yes, or... Yes, I'm sorry, Your Honor. Yes,
that's a yes.
Chief Justice John Roberts, who is very concerned with protecting Supreme Court precedent, or stare decisis, as well as the integrity of the court, posed a hypothetical to lawyers supporting the law.
Assume that the bounty is not $10,000, but $1 million. Do you think in that case the chill on the conduct at issue here would be sufficient to allow federal court review prior to the end of the state court process?
No, Your Honor, because that wouldn't affect either the Article 3 or sovereign immunity problems inherent in this case. Undoubtedly, it would increase the chill. Well, the injury would be akin to the one suffered in a tort of outrage, where a person witnesses something that essentially they find to be so extreme and outrageous, cause them extreme moral or otherwise psychological harm. That's
Give
how
me an
it works.
example of that.
An individual discovers that a close friend of theirs who they'd spoken with about pro-life issues and about abortion has chosen instead to have a late-term abortion in violation of SB 8, and they were very invested in basically in that child's upbringing, the child's coming into being.
Supreme Court experts caution that the justices' line of questioning is not always a reliable predictor of how they will ultimately rule. But Monday's arguments left court watchers thinking Roberts and Kavanaugh are the 2 conservative justices who are most likely to break ranks and side with the liberals. Jonathan Mitchell, the former Texas Solicitor General and the architect of the law, argued briefly before the justices on behalf of the state, saying that private citizens who bring this suit are not state-designated actors.
The state is not directing the activity of these private individuals. The state has passed a law that gives them the option to sue, and then it has washed its hands of the matter.
Liberal justices didn't seem to buy it.
Let's go in depth on this issue and what the arguments made there at the Supreme Court mean for the future of the law. I want to bring in law professor from Case Western Reserve University, Jonathan Adler. Thanks for coming on, Jonathan.
Good to be here.
Well, first, it appears a majority of the justices may be considering allowing abortion providers to pursue a federal court challenge to the Texas law. What are you making of that?
Well, I think quite a few of the justices are very concerned about states being allowed or enabled to enact laws that constrain constitutionally recognized rights. As came up multiple times in the argument, if Texas can do this with regard to abortion, then California could do it with regard to gun rights. New York or Montana could do it with regard to maybe campaign spending that's protected by the Constitution. Some other state could do it with unpopular speech. And states would, in effect, be able to constrain or chill the exercise of rights that the Supreme Court has recognized. And so the justices were really concerned about what the implications of allowing this law to remain in effect could be for our broader constitutional system.
And it's also a shift from a 5-4 ruling in September that allowed the law to go into effect, because it sounds like perhaps Justices Kavanaugh and Roberts may break ranks.
They might, and I think it's even possible that Justice Barrett might as well. Over the summer, when this question first came to the court, it came to it on what's referred to as the orders docket or the shadow docket. That's where a brief comes in very quickly. The justices have relatively little time to review it. There's no oral argument. And the issues in this case are sufficiently complicated that the justices really weren't sure what the precise way would be to enjoin the law or prevent its operation. And that, in fact, was another issue that they talked a lot about today. But having the opportunity for full briefing and for full argument, it's clear that a majority of the justices are at least concerned about the way this law operates and explored several possible ways that the court might be able to prevent its enforcement.
So the justices may allow abortion providers to pursue a federal court challenge, but at the same time, it doesn't appear to want to allow the Biden administration to do that. Why is that?
Well, the argument that's being made by the federal government is, in effect, that if people aren't able to bring suit to defend their own constitutional rights, that the federal government can kind of step in as the protector. And if the abortion providers are able to sue on their own behalf, then it's less important for the federal government to be able to come in and play that protective role. So one of the other things they talked about today was, if the abortion providers are allowed to sue on their own behalf, is there a need for recognizing the extreme equitable remedy of allowing the federal government to sue as well?
And if either abortion providers or, say, the Biden administration are allowed to sue, would that temporarily block the law in Texas?
Probably. I mean, so there's two questions, right? One is, can one or either of these lawsuits proceed? There's one lawsuit filed by the abortion providers. There's another lawsuit filed by the federal government. So the immediate question is, can those cases proceed? There's then a second question of whether or not the Supreme Court would enter a stay or injunction barring the enforcement of the law while that litigation proceeds. But those are two separate things that the court will have to answer. It will both have to answer the question of, can the cases go forward? It will also have to answer the question of what to do while that case is working its way through the courts.
Well, it was interesting to be able to hear some of these 3 hours of arguments today. We appreciate you helping us understand it. Jonathan Adler, we hope you'll join us again. Thanks.
My pleasure.